Welcome to Peachtree Injury Talk with attorney Jordan Jewkes.
Hello and welcome to Peachtree Injury Talk with Jordan Jewkes. Jordan strives to give injured victims a voice and provide strong advocacy against an often broken system. I am your host, Kevin Rosenquist, and today's episode is What If It's Partly Your Fault? Understanding Comparative Negligence in Georgia. Jordan, welcome back.
Hey, Kevin, good to see you. Thanks for having me.
Yeah, good to see you too. Let's dive right in. What exactly is comparative negligence and how does it apply to personal injury cases in Georgia?
Yeah, hey, really good question. And I know it probably sounds like a really boring topic, but it actually applies in a bunch of different ways in Georgia. And they actually have what's called a modified comparative negligence statute. But it's basically in Georgia, they have what they call what is maybe easily referred to as a blame pie, right? If you had a big cherry pie of blame, who's at fault for the wreck? Georgia says if you have more than 50% of that pie, if you're to blame more than 50%, then you cannot make a recovery. But anything under than 50%, you can make a recovery. So in other words, if you have if you have a little bit of fault, maybe 25%, you can recover 75% of your injury or your damages for the wreck, up to 50%. But if you're 50% or more, then you can't recover. That's what they call the modified comparative negligence rule. So you can take on some amount of that blame pie, but not more than half.
Okay. So have you ever seen anyone?
Is that sufficiently confusing for you?
No, I get it. I was just curious. Has anyone ever been at 49% in your experience?
I mean, that's obviously the golden way. That's an argument you make to the jury, and you essentially say, look, we admit we have some fault, but we're not more than 49% at fault. I mean, you're really splitting hairs at that point.
Right.
But that's the argument you make, because if your client has more than 50%, they cannot make a recovery regardless of how bad they're injured.
So that you said the jury decides it. Is this only in a case where it goes to a jury, or can there be comparative negligence even if it doesn't go to a jury?
Yeah, no, that blame pie applies from day one. And so if a client comes to me, and sort of the traditional case is, hey, we were turning and they were turning at the same time and we both hit each other. I mean,
right.
I just talked to a potential client not long ago who said, hey, I was backing out of a parking space and someone hit me. And so my analysis from the very get-go is they need to have, my client or my potential client needs to have 49% or less blame, or I probably cannot represent them. And we're pretty good at what we do here. But if we think an adjuster who has the same knowledge of the law, or at least has same access to the law and their own attorneys, if an adjuster is likely to blame my client for more than 50% or for 50% or more, that's a really tough decision we have to make about whether we take that case. So yeah, Kevin, I mean, that's an analysis you need to make long before you get to trial.
Yeah, that makes sense. So in a case where, there is blame on both sides, who decides that percentage if it doesn't go to trial? Is it something that like the parties would agree, like, okay, I was definitely more at fault or something like that? Is that kind of how it works?
I mean, every case is going to be different, but it ultimately comes down to a jury, right? And so a good attorney, and really frankly, a good insurance company or adjuster for the insurance company, is going to try and forecast what a jury might do. Mm-hmm. Right. And in Georgia, what a jury of 12 folks are going to do and how they may decide the case. Because if it's clear or becomes increasingly clear that a jury is going to blame your client or blame you for 50% or more of the case, you need to get out of it and be honest and say, hey, look, we just don't think the jury's going to find that you have less fault. I mean, so yeah, you need to make that analysis early and up front. So yeah, we're just prognosticators really of what a jury might do.
Right. Well, do insurance companies try to use comparative negligence to minimize their payouts? Will they try to manipulate that?
I mean, yeah, that's an understatement. Of course, yeah. I mean, the insurance companies, they will exaggerate actually the payout, or rather the percentage of fault for your client to avoid paying out.
Right.
And you see this all the time. I'm like, we had a case once where a driver of ours had to stop suddenly because of the car in front of them stopping suddenly, and then the defendant driver ended up rear-ending them. Well, our client never actually hit the car in front of them, but they were hit by the driver behind them, right? The defendant whom we later sued. And that defendant tried to say, well, it was your fault because you stopped so suddenly. Well, I mean, my client, though, was able to avoid the impact with the driver in front of them. So how can they be at fault if they were able to avoid, but the person who hit them wasn't able to avoid?
Right.
It's obviously the person behind them wasn't paying attention or wasn't keeping a safe enough distance. So the insurance company is always going to look to assign more fault than is reasonably necessary to your client. And so that's why it's so important to kind of look, at the extraneous evidence. Is there witnesses? Are there cameras? What did the police officer say? Those types of things.
Yeah, I was going to ask about the evidence in these kind of cases. Does it change? Is your approach different for a comparative negligence case as opposed to maybe one that doesn't have it?
I mean, I don't know that approach changes because we always want to collect the evidence we have, but the emphasis may change in how we approach the evidence. And what I mean by that is if it's a potential case where we think that the insurance company is going to try and lay some blame on our client, we want to make sure we get the police body cam or dash cam. We want to make sure we talk to the witnesses, and that sort of becomes the emphasis. And honestly, Kevin, we talk to the insurance companies from the get-go, right? I mean, once a client signs with us, we immediately start communicating with the insurance company, and we describe the injuries. We kind of give our narrative of what happened because we want to control that narrative. And if we think the insurance company is going to start saying, well, your client's partially at fault, we want to start emphasizing, well, look, here's the police report. Here's the video from the police scene or at the scene. And here's actually what the two parties, both drivers, said. And if we know that hurts us, we want to get ahead of it to sort of let the insurance company know, yeah, I know this is what was said at the scene, but here's actually what the video cameras show, et cetera, et cetera. Because, there's certain times we are going to want to emphasize that our client did not have fault. If we suspect the insurance company is going to try and lay blame on us.
Yeah. Is it something where you don't want to? You don't want to admit any fault early until you see what their plan is? Yeah,
of course. I mean, and we say that to every client, don't go admitting fault. But really what you'll see is folks just want to be nice and they want to avoid confrontation at the scene. And so, given this law, it discourages apologies or the need for apologies. Because sometimes you say, oh, I'm so sorry. And you're not accepting responsibility. You're just trying to be polite. But insurance companies will take that apology and they'll say, well, your client admitted fault at the scene because they apologized. And because of that dialogue and that back and forth that we so often expect from insurance companies, that can be really hurtful to a claim. We tell folks, if you get in a wreck, don't admit fault, but B, I wouldn't even apologize because the insurance companies will try and blame you for your apology.
Do you like this comparative negligence rule?
Look, I think like most laws, I think there's some good intention behind it. But the problem is the insurance companies tend to take advantage of it. Mm-hmm. And anytime the legislature passes a law that's intended to improve the civil justice system, whenever they try and say, well, look, if a person who's injured has some fault, they shouldn't be able to recover so much. And so a lot of states actually have adopted what's called a purely comparative negligence law. And again, this is different from Georgia, but in that one, the statute is, or the law is essentially you get whatever pie or share of the pie that you are not responsible for. So even if you cause the wreck and you're 75% at fault, you can still recover the 25% of your injuries. So, do I think the law is fair? Yes. Do I think the insurance companies play fair with it? No.
Yeah. Okay. That makes sense. I could see that. Is it tough to figure out liability in these situations? I mean, it just seems like there's no calculation, obviously, that you're putting into a computer program or something to figure out fault. I mean, it's just, there's a lot of different moving parts. It's got to be kind of difficult to figure out where percentages lie. Yeah, I mean, that's true. And it comes with experience like anything else. And every case is different. And in some cases,
the injuries certainly warrant a very deep investigation, even if we think there may be a higher percentage of fault on our client. But yeah, I mean, some cases are going to be much tougher. If you rear end someone, for example, I mean, 99% of the time you're going to have a bigger share of fault. And there are some exceptions to that, but typically that's going to be a tougher one. But for the most part, if there's a T-bone or two cars kind of turning into each other, it's going to be, who's got more witnesses and evidence. The one where I had recently where someone called in and they had they were backing out of a parking lot and someone hit them. They actually had video camera of the whole thing. And so I was able to talk through with them what I thought about their case. And honestly, I thought it was a tough case for them.
Yeah, because I can picture that. We've all been there, right? And I can picture like pulling out of a spot and you see that car and you're like, oh, and you stop. But yeah, it kind of feels like if you're pulling out of the spot, unless the other person is driving the wrong way or on a one-way parking lot or something like that, it's kind of tough to not have some blame there.
Yeah, and fortunately in that case, and a lot of parking lot cases, there wasn't a real injury, and they were just trying to figure out whose car or which insurance company needed to pay for the damage to their vehicle. And that's a good situation to be in, where you're not having to go to the hospital and recover for medical bills and pain and suffering. And we try and help out folks on those types of cases as well. But yeah, I mean, you're right. It was a really tough call.
When you're dealing with commercial vehicles, ride shares, stuff like that, where maybe there's a larger company behind the scenes, does it become harder, like a trucking company or something? They've got, they're trying really hard to fight against it. Did they try to manipulate it too?
Oh, certainly. And the bigger the company, the harder they usually try to get out of liability. Mm-hmm. But also, the technology is there now to where a lot of these larger corporations, especially trucking companies, have so much data. And a lot of it is safety driven, but they have a lot of technology and data at their disposal. And a lot of these trucking companies have outward facing cameras. So cameras that capture really what the driver is supposed to be seeing, but also inward facing cameras so that where the driver's eyes, what they're pointing to, or if they're listening to something on the radio, or if they're, believe it or not, if they're watching some screen on their phone or a tablet, you can usually find that out. But they also have data that shows how fast they were going, when they applied the brakes, the acceleration speeds, all of these things. And so for a trucking company, believe it or not, you can usually sort through that data. As long as you collect it up front, you can sort through that data pretty easily and get a lot of good information that you may not have readily accessible on just a typical, two commuters to work or two moms, crashing into each other or something like that. And the same thing is generally true of rideshare. Once that app is engaged, it collects a lot of data about how fast, where they're going, when they turned, all those types of things.
Interesting. Very interesting. So what about when there's 3, 4, 5 cars involved? Can it get down to just a fraction for each car?
Yeah. I mean, we've had cases where 4 or 5 vehicles are involved. And the easy ones are when it's a rear end. The tough one is when there's an impact, he spins on the freeway or something and hits someone else, or when someone tries to swerve to avoid a deer or something, and then they hit another driver or something like that. But certainly, I mean, the old saying, the more the merrier.
Not in this case, huh?
It's you still have that one piece of pie, generally speaking, and so you've got to now instead cut it up into make just one slice. You've got to cut several slices, and that becomes more difficult, and the insurance company starts blaming things. But every case is different. But yeah, the more vehicles, the more difficult it is, typically speaking.
Yeah, I was thinking about that, like, because I suppose then if there's somebody. If somebody's, like less at fault, they're still not going to get as much of their damages recovered because it's all based on 100%, right?
Yeah, that's
you can't
exactly
have two
right.
drivers who are 75% responsible and one who's 10. It doesn't work.
Yeah, and so sometimes we just say to the insurance company, look, and sometimes our driver is 100% not at fault, and there are 2 drivers that hit them simultaneously, or there's 2 drivers who broke the law somehow. And sometimes we've got to file that case, even though our client has 0 fault, because the insurance company from driver A and driver B can't agree on fault. And so one will say, well, you're 75, you're 25. Well, our client is truly the victim with 0 fault.
Your client 0. Yeah.
Yeah. But because there's 2 other drivers and the insurance companies for each can't agree, they sometimes we'll have to file suit. There is something that helps out on that process occasionally, and it's something we don't see directly, but there a lot of insurance companies will file for arbitration early on, within a month or two, sometimes under 6 months of the wreck, and the two insurance companies will present evidence in sort of a it's not really secret, but it's not something that we get invited to. But when there are two insurance companies involved and they're trying to figure out liability, and they know that if they can't figure it out, a lawsuit will be filed by us. They will go to an arbitrator or like a panel, kind of like a judge, and that arbitrator will hear the evidence presented by the insurance companies, and they'll make a determination of fault. And then usually that is binding, at least amongst the insurance companies, and then they'll let us know what the arbitrator decided. They'll say, well, the arbitrator said we're 60% and we're 40%. And that simply means, well, we want 100% of what happened to our client. We'll take 40% from insurance A and 60% from insurance B, and then we'll settle out and be done with the case.
Okay. Wow. Complicated.
Yeah, that's interesting. And we're not a part of that at all. We just
right. You don't even get to be part of it. Yeah.
And that's not binding on us. If our client doesn't like that result, or if one of the insurance companies says, well, we're not going to play ball, we're not going to agree with the arbitrator's decision, it's fine. We'll file a lawsuit.
Yeah. Then you have to move on. Right.
Yeah. We'll let the jury decide.
Let the jury decide. Yeah. Yeah. Man, interesting. I could see how that could get really complicated as an attorney, for sure.
Yeah. I mean, that's what we do. And sometimes the unsuspecting, driver victim who really has no fault, the insurance companies will really try and take advantage of them. But that's typical. That's what insurance companies do, and that's why we have jobs.
Yeah, that's why you exist. Your job exists. Exactly. Yeah, for sure. All right. Well, thanks for joining us today on Peachtree Injury Talk with Jordan Jewkes. To connect with Jordan and the team, visit jewkesfirm.com, and please like and subscribe to our channel. We love having you here, and we got lots more stuff coming your way. Jordan, thanks so much for your time. Really appreciate you being here.
Yeah, thank you, Kevin. We appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.